5, 4, 3, 2, 1. It is submitted that the suit was initially dismissed. However, it was subsequently allowed partly in the appeal, and respondent number 1 was granted a right to put up a shutter on the window without disturbing the structure of the shop, and also making it clear that the window would not be converted into a door at any stage, and the window would also be not made a regular business opening. It is contended that the relief claimed in the present suit would directly affect the rights of the petitioner pertaining to the kiosk allotted to him, and as such the presence of the petitioner is necessary before the court. Subject application was dismissed by the trial court, holding that the suit has been filed by the respondent number 1 against respondent number 2, and relief, if any, would be granted as per the rules and regulations of the Municipal Corporation of Delhi, and that there was no dispute between the petitioner and the respondent number 1, and there was merely an apprehension that if relief claimed is allowed, it would affect his elementary rights, and merely on an apprehension, impediment could not be allowed. The trial court has come to a conclusion that the petitioner is neither a necessary nor a proper party to the suit. His articles for display much beyond the area of a shop on the public pavement as well as the street. It is contended that if opening on the southern side was permitted, the passage between the shop of the respondent number 1 and the kiosk allotted to the petitioner, which is only 6 feet, would be encroached upon by the respondent number 1, thereby directly affecting the elementary rights of the petitioner, as also invade on the privacy of the petitioner, as there is an opening on the kiosk of the petitioner from that side. Learned counsel for the respondent number 1 submits that in the earlier suit filed by the respondent number 1, petitioner had filed a similar application under Order 1, Rule 10 CPC seeking impediment. Said application was dismissed. Even the appeal filed by the petitioner impugning the dismissal of his application under Order 1, Rule 10 CPC was rejected by the High Court and also by the Supreme Court in a special leave petition filed by the petitioner. Learned counsel for the respondent number 1 submits that the said order would operate as res judicata in as much as the right of the petitioner to intervene in the subject suit is concerned. Further, it is contended by learned counsel for the respondent that the dispute is purely between the respondent number 1 and the corporation respondent number 2. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.